In 1798, the state of New York agreed to grant Robert Fulton and his partner, Robert R. Livingston, a monopoly on steamboat navigation in state waters if they developed a steamboat capable of traveling 4 miles per hour upstream on the Hudson River. In 1807, Fulton's ship, the Clermont, sailed up the Hudson River from New York City to Albany, New York, at an impressive speed of 5 miles per hour.
Shake hands with Blake and hand him the piece of paper.
Congratulations on being able to successfully build a steamboat that can travel upstream along the Hudson River more than 4 miles an hour. Here's a monopoly on steamboat navigation along our great state.
Thank you, sir. Does this monopoly mean I can sell the rights to steamboat navigation to others?
Yes, I do believe so. I believe that is the case.
Later.
I'd like to purchase the rights to steamboat navigation along the beautiful waters between New York City and New Jersey.
Here you go, Aaron Ogden. Enjoy the rights to navigating the waters between New York City and New Jersey.
Meanwhile, Thomas Gibbons, Ogden's former business partner, wanted to compete with him. Gibbons obtained a license from the federal government based on an act of Congress to operate his boats in the same waters.
You don't have to read that.
What are you doing here?
How
did you get the exclusive rights to steamboat navigation of the waters between New York City and New Jersey?
I obtained a license from the federal government by the Commerce Clause of the Constitution.
You can't do that! I'm suing you in the New York Court of Chancery for operating steamboats in these waters without the authority of Fulton and Livingston.
We were friends, partners, friends even. I'm sorry. I'm so sorry.
Later.
The court rules in Ogden's favor. Mr. Gibbons, you did not have the right to navigate the waters between New York City and New Jersey with your federal government license. Ogden retains the right to navigate the waters between New York City and New Jersey with his license obtained from Fulton and Livingston given by New York State.
This isn't over, Ogden. I will appeal to the Supreme Court of the United States. New York State is violating the Commerce Clause of the Constitution. Staunch Federalist John Marshall shall hear my pleas.
We shall hear about that.
On March 4, 1824, Gibbons and Ogden made their case to the Supreme Court.
Good morning, Your Honor. I'm Samuel L. Souther, defendant Aaron Ogden's lawyer. The fundamental question today is, Your Honor, does the Commerce Clause of the U.S. Constitution give Congress the power to regulate interstate navigation and to override any state laws that interfere with interstate flow of persons and goods? My client was operating within his rights when he navigated the waters between New York City and New Jersey with his license from Fulton and Livingston. The word commerce is defined as the activity of buying and selling, especially on a large scale. My client was not in violation of the Commerce Clause because mere navigation and transportation of goods or people is not interstate commerce, because nothing is being bought or sold. Additionally, congressional power to regulate interstate commerce is a limited power and does not extend to navigation within a state's own territory, including its waterways. In conclusion, the Constitution grants the authority to decide who may conduct business within state's borders, including by granting exclusive licenses to operate in its waterways, as in the case of my client. Okay, we're gonna stop it so that I don't have to re-record that if you mess up.
Good morning, Your Honor. I, Daniel Webster, representing Thomas Gibbons. First, considering the fact that to navigate the waters between New York City and New Jersey, you have to travel from the state of New York to the state of New Jersey, classifying the navigation at hand interstate. Transportation of goods or people is inherently providing a service and can be classified as commerce. In summation, navigation involving transportation of goods and people between states is interstate commerce. Congress retains the power to regulate, as noted in the provisions of the Commerce Clause of the Constitution, by giving people the right to conduct business across state borders and into a state, like in the case of my client. Additionally, Your Honor, the court case of McCulloch v. Maryland demonstrated that when the state and federal laws conflict, the federal law is supreme, and the state law should be struck down. I have no additional points.
You were my friend!
After much deliberation, Chief Justice John Marshall has prepared a decision.
Gentlemen, the court has ruled unanimously in the favor of Thomas Gibbons. The New York State license was unconstitutional because it conflicted with the license granted by the federal law. All of America understands the word commerce to include navigation. It was so understood when the Constitution was framed. Under the Articles of Confederation, the states could pass laws that regulated economic activity outside of their borders. Many states created self-serving and protectionist trade between and among the states. The framers understood this when writing Article 1, Section 8 of the Constitution, better known as the Commercial Clause. Commerce refers not only to the buying and selling of goods, but also to commercial intercourse, including navigation. However, Congress' power under the Commerce Clause does not extend to the regulation of commercial activity taking place completely within one state, which does not extend to or affect other states.
What you know about rolling down in the deep when your brain goes numb, you can...
What a mess we've created.
It's okay, my son. The state of New York. You live and you learn. This has been an important development in the interpretation of the Commerce Clause of the Constitution, and has set the stage for future expansion of congressional power over commercial activities and a vast range of other activities once thought to come from within the jurisdiction of states. I'm so proud of you. You're so strong.
Does this mean that any state law regulating in-state commercial activities could potentially be overturned by Congress if that activity was somehow connected to interstate commerce? For example, workers' minimum wages and an in-state factory that's goods are sold across states' lines?
Yes, my boy. In addition, it marks the end of state monopolies on services relating to interstate commerce, such as navigation and business competition. The end.
The end.